Let's begin here. The High Court in Pretoria today heard that several people had to carry soccer star Senzo Meyiwa to the car after he was shot. Meyiwa's close friend, Tumelo Madlala, who was present when Meyiwa was shot, continued to give evidence in the murder trial of the goalkeeper. Madlala says there were already people outside the house soon after the incident and assisted them to carry him to the vehicle. Meyiwa was shot and killed in 2014 at an alleged robbery. He was visiting the home of his then-girlfriend, Kelly Kumalo, in Vosloorus. Madlala says he, however, cannot remember how many people carried Meyiwa to the vehicle before he was rushed to hospital. Let's stay with the story and speak to Sinawo Makangela, who is a legal analyst. Sinawo, thank you so much for your time this afternoon. He's the first witness who was in the house to give evidence, especially hearing how, Senzo Meyiwa fought the perpetrators before the shots rang out, that shot rang out, and people taking him to the car, giving us a sense that there was a soccer match that was also being watched. Are we now, according to you, getting a clear understanding of what may have happened in that house that night?
Thank you to the viewers as well. I think now we're getting closer now to know what actually happened on the day. This is somebody who was there, but the sad part is that as he testified, there may be some gaps with his evidence, as well as that of other witnesses who have testified already in the form of the police officers and what happened, who was there when they arrived. Because some of them, I think one sergeant talked about who went to hospital, who came in first, who came in late, and that may affect the state's case if you look at it in that angle. But at least now we do have a picture of the mood of the day, what actually happened on the day, because this guy was there on that day.
And you say that, how the police had presented the case as well may have an impact on the state's case. Are you then looking at how the police have told the court they handled the scene and how they came under fire? Or is there something else here from their perspective that could prejudice this particular case from the state?
Glaringly, the captain said there were no people when he arrived there outside. In fact, the very same captain said there were people. The sergeant, I think they also talked about who came in first, who came in last. The sergeant said, well, to him that was not a crime scene. It was just like a normal house. The captain presented a totally different picture. And remember, there's what is called an onus, and obligation lies with the state here to prove its case beyond any doubt. If there's any doubt, it jeopardizes the state's case, and the court will have to find in favor of the accused persons.
Especially, sorry, Sinawo, if I may, before you even move on from the issue of owners, especially when we look at those concerning statements that even emerged in court that we saw last week, that one of the neighbors was seen removing the beer bottles and nothing was happening and people were going in and out, possibly contaminating the scene.
There's a lot. Wait until you hear when they argue. At the close of the whole case now, when both parties are arguing, you will see, because what the defense has is just a small task to pinpoint, to show the judge that, my lord, they've failed to prove their case beyond any doubt, and then they bring the doubts that are there. Remember, as I say, glaringly, nothing dealing with the crime scene, nothing was done that clearly demonstrates that it was a place that had to be cordoned off to ensure that only the police officials who are expertise in dealing with the sins only deal with it. There was tampering, everyone was doing as they please in that whole scene. And as I say, those are some of the issues that are there. Again, what they say in their own statement, in their own testimony, by the way, without even hearing what they have to say in their statements, what they say in their own testimony. One guy who's an expert can't even provide expertise, but is said to be an expert. Then there's this eyewitness. Remember, what you want, at least with this one who came in today, is to say, I saw accused number 2. I saw accused number 3. So that you must be able to link the guys who are charged today. What he has said already, I could not say them. Because remember, if there was a shooting, as soon as you hear the gunshots, you run for your own life. Remember that there's some ways that I could not see anything because I was running for my own life.
So then,
obviously now the court will have to deal with his evidence with a very serious caution to say the court can rely on his evidence.
Pardon me, Sinawo, then I cannot help but think about a complication that is going to arise then here, because there was that issue of the identity parade that was canvassed quite greatly, and we saw even the defense attorneys coming out saying, no, you cannot keep putting questions like this. He said he wasn't present at this ID parade, he wasn't present at that, and then he continues then to say, I'm angry because I'm seeing this particular individual here, and at the same time, as you say, because we did hear him say that after the shot rang out, he ran, away to a bedroom. How easy then is this all going to be, to prove, listening to the fact that the state tomorrow is going to be presenting some, legal heads there of arguments to be able to justify why they want to ask him about these identity parade issues?
Just imagine me and you are having questions than answers. You would expect if a witness comes, is here to provide answers. He was angry to see this person, he ran. At what stage, at what moment did he see this person? Those are the questions that he should be providing. The role of a witness in a court of law is to provide clarity so that a judge can administer justice properly. Remember, at this stage, it's not the stage of an argument. The state can't even present the evidence of the identification parade because there is a procedure that must be followed in the identification of the suspects. Remember, at that stage, no one has been charged, but there are people who are suspected to have committed an offense, whether through the heights, some features, so that if the witness is certain, the witness is able to identify the culprit amongst a crew of those people who would be brought to the identification parade. So even when you introduce that evidence, remember, the process is simple. You bring a witness, you lead evidence. The defense comes, ask questions, whether it creates doubt in the evidence, whether it's cases that court don't accept this particular part of an evidence. Then later on, the parties argue. They prepare the heads of arguments. I mean, the state wants to argue its own case. The defense is yet to ask a question. The defense is yet to lead a single witness. The state is leading a witness. The defense has prepared heads of arguments. On what basis? So you can say that the state is, I don't know whether it's blowing hot and cold, but it's shady how the whole thing is being handled.
Phew, so now, one cannot even help but have a litany of questions after what you've said. But let's talk about then the other people who were in the house, given the fact that we're now hearing from Tumelo. We've heard before from Kelly Khumalo's lawyer, for example, saying she doesn't know if her client is coming, will be called or not. They still are trying to get clarity, and she's on a watching brief. Now with Tumelo on the stand, do you think we will see more people who were in the house come to give evidence, possibly?
Sisibongiwe, the matter was certified, the trial already. Remember, before the trial started, the court satisfied itself that everything the defense has been provided with all the information it would need to prepare for its own trial. That information would include the statements of witnesses. So if those people that were in the house at the time have made statements to the police, obviously the state will call them. Remember, it's not the stage of an investigation now, it's the stage of the trial. But as it appears that Kelly Khumalo is not a witness, as you could see that she had her own lawyer in court, it means she's not a state witness. And those people that she was with in the house, it is unlikely that they will be of assistance to the state. It means the state did not even bother itself to bring them on board. As you could see the second docket and the first docket, that they appeared to be the suspects in one docket that was not brought, or that is not the one that is serving before court in the current proceedings. So them are not state witnesses. What does that mean? It means the state will not be getting assistance from them as the people who were in the house on the day.
Do you get a sense, though, listening to what you've just said now, that the state is still trying to piece together some things here, conducting an investigation, or are they simply, having a watertight case, as they have said, looking at what has happened?
Well, with the few witnesses that have testified, there is no indication of a watertight case. Maybe other witnesses are coming who will demonstrate that watertight case. But with these witnesses, there is no watertight case. First witness does not even know who committed an offense. He's not even an expert. He's referring to the late, I think, is it Captain Love? They make reference to Captain Love. We know that in law, some of the portions, if no proper application has been made in court, anything that is needed, the late Love to confirm, will be struck of that evidence, will not form part of the evidence that will be considered by the court. So, looking at the witnesses that have testified up to this moment, there is no watertight. If there was a watertight case, you would not be having questions. I would not be having questions. We would be all having a clear understanding of what actually happened on the day. They would be presenting a coherent case. There is nothing coherent here. You can't even tell. The other one comes, speak from his own corner, another one from his or her own corner. So it's a bit chaotic, clumsy. And as we say that the Constitution guarantees that protection. For any trial to proceed, the state must say, we are ready. Once the proceedings are set in motion, the trial has to run.
All right. Sinawo, lots of questions, as you say. Let's talk again then in future, because it looks like we are probably going to, really need a lot more answers than has been forthcoming. But let's leave it there with you for now. That was Sinawo Makangela, a legal analyst, as we really look at this particular Senzo Meyiwa murder trial. Lots of questions, but let's see in the coming days how it unfolds.